Hello, everyone. This is Bland Hallman in Chapel Hill.
And this is Cale Jaffe in Charlottesville. Thanks for joining us.
This Monday, April 2nd, 2007, was a great day for clean air. The United States Supreme Court handed SELC a tremendous win in our enforcement case against Duke Energy. And in a separate case, the court issued a favorable ruling on the federal government's authority to regulate greenhouse gases.
These two decisions together are a strong affirmation of the Clean Air Act. It's really a 1-2 punch for clean air and a repudiation of industry abuses and government's attempts at rollbacks. This particular case, of course, started back in 2001 when the Southern Environmental Law Center intervened in an enforcement case. We've been slogging it out now for 6 years, and it's been critical to have SELC's involvement along the way. We petitioned the Supreme Court to take the case back in Christmas of '05, and the EPA actually opposed our petition to get the Supreme Court to review the case, but over EPA objections, the Supreme Court agreed to hear our arguments, and oral argument was set for November 1st of 2006.
So oral argument, this picture was taken after oral argument, and everyone looks happy. But I must tell you that there was somewhat worrisome. There were many hostile questions directed our way, suggesting that members of the court were sympathetic to the reading of the regulations that industry had served up in their briefs. And almost as soon as Sean Donahue, who argued the case for us, started in with his presentation, stating that the regulations were clear in their face, Chief Justice Roberts pointedly characterized that assertion as being audacious, a quote, audacious statement, which is a little unsettling to have happen early in your presentation from the new Chief Justice. Some justices were just silent. They didn't ask any questions at all, in particular, Justice Souter.
And so after that day of oral arguments and a little nervousness, we remained cautiously optimistic. And then came the waiting, 5 months of it. We thought that there was a possibility we could get an opinion as soon as 2 months afterwards. So really, beginning in January and February, we're following the blogs that cover the Supreme Court to see if there's any buzz about the case, and we're checking in with the Supreme Court to see if there's any news. And each day, that we knew that there might be an opinion announced, I'd come into the office and just anxiously hoping that today we'd get our answer. On April 2nd, today we actually did get our answer. I came in that evening was to begin Passover, and I was hoping to leave at noon to start the preparations for the Passover Seder. So when I came in and I saw that the blogs that cover the court were buzzing that we might get an opinion today, I was saying, oh gosh, I hope they're wrong, because I really could use the chance to leave a little early today. But of course we did get the opinion, and just the excitement was electric. Folks started filing into my office. Jeff Gleason was there. Rick Melton was there. We're all standing around trying to read the opinion at the same time. At first, we see that it's a unanimous victory, and we're thinking, well, they must have decided it on very narrow grounds, but that's part of how we expected we might win this case, so we're happy. And then as we read it, we get farther into it, we say, well, maybe it's narrow grounds, but there seems to be some meat on it here. And then the farther we get into it, we realize, wow, there is a lot of meat here. This is a huge victory, and really as much as we dared hope for.
That's absolutely right. You'll remember Chief Justice Roberts characterizing our position on the clarity of the regulations as being audacious. Well, it turns out that the position wasn't our position that was audacious. The court had no trouble finding that the regulations were clear on their face in our favor, and if anything, it was quite a rebuke to industry's view. The court could have ruled very narrowly on, there's a nice jurisdictional question in this case that would have been a very narrow grounds for reversing the Fourth Circuit, but the court went further, and it clearly resolved a central question in new source review cases about how to measure emissions increases, and rejected industry's view and didn't take much time doing that, frankly.
Yeah, and as Bland points out, I think that one of the key points of the decision is that it's such a strong opinion for us on the merits of what new source review means. Justice Scalia, even during oral argument at one point, said in response to our side that I think you may have the better of the argument on the interpretation of the regulations. And in fact, that was upheld with the opinion when Elizabeth Sjogren was interviewing Bland for All Things Considered on NPR. She led off the story by saying that the Supreme Court stood up for the environment and sends a rebuke to the owners of dirty coal-fired power plants.
There was tremendous interest in the case across the country. You'll have noticed there was a slide about 4 back of Justice Souter, who I mentioned earlier, and who I said was silent in the oral argument. I neglected to mention just now that this 9-0 decision was authored by Justice Souter. So his silence, I guess it was not a bad thing that he didn't say anything in the court, because he said plenty in this opinion that will absolutely be setting the stage for these other cases like Duke Power, the Duke Energy case. There are other cases across the nation. Alabama Power is one of them. That's why the Atlanta Journal-Constitution is so interested in these things, because pollution from the Alabama power plants goes into Georgia. And the Alabama Power case is now before the 11th Circuit Court of Appeals. They called a timeout in that case to see what happened in Duke. We now see what happened in Duke, and that case will be reactivated. But it's not just the Alabama Power case. If you see on the map here, we've got the cases which are subject to currently pending NSR suits, new source review suits that are similar to Duke. You can see Duke's plants in South and North Carolina, Alabama Power's plants down in Alabama. You've got some Synergy plants up in the Midwest. These will all, this ruling will affect all of those cases. We've calculated that in 2005, 1 year alone, these plants emitted 1.6 million tons of sulfur dioxide, which is a lot of sulfur dioxide, and it's coming from not that many plants. So these are disproportionately relatively dirty plants. We're hoping that the resolution of this legal issue by the Supreme Court in such forceful terms, and not on a very narrow grounds, but fairly broadly, will induce discussions about how to clean these plants up now rather than having to slog through more years of litigation to make it happen.
Yeah, and as looking at that map and realizing just how dramatic this win could be, it really emphasizes how powerful the law can be to affect positive change as we try to protect the environment. But our work is far from over. The afternoon of the opinion, Duke Energy already had their press release out where they said that they were going to continue to fight this out in the lower courts. Scott Siegel, who is a lobbyist for the electric power industry, was quick to express his disappointment and say that, quote, the court missed an opportunity to once and for all clarify the new source review program. Well, Scott, the court actually did clarify the program. You just don't like what they had to say. And I think that quotation from Mr. Siegel really emphasizes what we've been up against for the last 30 years and what we're going to continue to have to face as we slog this out. If industry doesn't like what it sees, it pretends it doesn't understand. And the result is we got to keep litigating. We got to keep fighting. Now this case in particular goes back to the Fourth Circuit Court of Appeals. We possibly would go all the way back down to the district court in the Middle District of North Carolina. But we've got a lot more work to do to make sure that the Supreme Court's strong ruling is enforced and implemented.
Overall, this case, I mean, at the end of the day, is with the companion case, or not the companion case, but the climate change case, in the same decided in the same day, is really shows you what the power of the law is to stop industry abuses and policymakers bent on rolling back enforcement. So it was a great day, I think, not just for clean air and for those of us who were involved, but for environmental law, to see the High Court of the land embrace environmental law and enforce it. It also illustrates the importance of having citizens get involved in these lawsuits to push the government along and for them to be represented by groups such as SELC, who has the capacity to stay in these things for the long term. We knew it wasn't going to be a quick payoff, but we were in it for years, and we will continue to be in it for years because there's going to be a big payoff in the end in terms of clean air. And we obviously couldn't have done it without our supporters who've enabled the organization to stay with this case for as long as we have. And it's been a great opportunity for, I know, myself and for Cale and Jeff Gleason to be involved in a case that has touched on every level of the judiciary that's available so far. So now I think we can open it up for some questions. I know that a first question we've got is how does the decision in the Duke New Source Review enforcement action relate to the carbon dioxide ruling that was issued the same day? Cale, I don't know if you want to take a crack at that one.
Sure, I'll start with that. Well, you know, the phrase we've been saying, this is the 1-2 punch for clean air and the fight against global warming. The greenhouse gas emissions case, the other case, Massachusetts versus EPA, affirms that under the Clean Air Act, EPA does have the authority, if it chooses to do so, to regulate greenhouse gas emissions, including emissions of carbon dioxide. It doesn't mandate that they have to do anything right away. I think the political pressure coming out of that case will be such that whether it's EPA perhaps in later years or whether it's Congress in later years, that we will see coming out of that decision some greenhouse gas regulations, but it's not going to be next week. Our case has more of a short-term and hopefully more of a short-term immediate impact because the decision is clear that we're right on this regulation that is already being applied in this enforcement case. And so the hope is that once we get this implemented, it's going to lead to short-term reduction. So we can begin making progress today by paving the way through our victory in the Duke Energy case for replacing these old, dirty, outdated plants with newer technology and hopefully newer technology that has that's more protective of the environment, not just on smog and soot, but also on carbon dioxide emissions. Another question we've got here is one that it says, you mentioned the Alabama Power case. What's next on the horizon there in that case? Blaine, do you want to talk a little bit about Alabama Power?
Absolutely. The status of that case is back in the fall, the 11th Circuit Court of Appeals, which that's where the case is now residing, stayed the case to say, you know, let's see how this plays out at the Supreme Court level. Now that it's that's happened, presumably what's going to happen is we will go to the Court of Appeals and say, listen, this is how Duke was decided, and this is what it means for that case. I think it's unclear whether or not the 11th Circuit, what it will do exactly. It could decide to send this back to the district court below for reconsideration of the order below that the judge issued in light of Duke Energy, or the Court of Appeals in the 11th Circuit could say, okay, well, we ourselves can read the Duke opinion and we see that it's at odds with what this lower court said on this emissions test question, and so we will apply the Duke Energy decision to that, and they should reverse it, and then could go on to reach another question that's live in that case at the appellate level, which is, were the projects undertaken by Alabama Power, were they routine maintenance? And so that those questions could either be resolved by the 11th Circuit, or it might decide to send it back to the district court level for further decision making there. It does. I think it's safe to say that the Alabama Power decision or case becomes now the one that's furthest advanced. Yeah,
I think that hits it well. The next question we've got is another hard one here. It's what reaction have we heard from the EPA or the Justice Department, and how will that affect EPA's proposed revisions to the regulations? Just a little bit of lead-in on that. As you may have heard, while we're fighting here to enforce the case, we're also working hard to fight EPA rollbacks at the federal level. The regulations that were enforced in this case were initially enacted in 1980. The EPA has been trying to revise those regulations, effectively roll them back with revisions that were put out in 2002 and 2003. Blaine, have you heard anything from folks at EPA or DOJ yet?
I have not heard anything from anyone at EPA, which I don't think I probably will be hearing much from them about their proposed rulemakings. I doubt that any conservation groups will, frankly. I know that the Department of Justice, which enforced this case against Duke, is obviously very excited about the line attorneys and the attorneys who've worked on it, very excited about the outcome. What it means for EPA's revisions to NSR going forward is going to play out in the courts. Currently pending before the Supreme Court is a petition to review a D.C. Circuit decision striking down elements of the Bush administration's NSR rollback. We anticipate that the Supreme Court will not take that case up. And so some parts of the Bush administration rollbacks will be are just not going to succeed. And there is the latest proposal by the administration, perversely back in, I guess it was fall of 2005, when the Bush administration proposed to embrace the Duke Energy opinion that the Fourth Circuit had announced. They said, well, it looks like there's some disuniformity caused by this Fourth Circuit opinion that contained an hourly rate test, and so to solve the disuniformity and for some other policy reasons, we're going to propose that hourly rate test. Well, now the Supreme Court has rejected the hourly rate test under the pre-existing regulations. That rationale for having a new rule to fix the disuniformity, that rationale is now gone.
Yeah, I think I agree with Blaine. That's one of the biggest bonuses here is that the attempts by EPA to impose this hourly rate test prospectively take a real hit because the Supreme Court has given us a strong statement in favor of the existing annual actual emissions test, how pollution is being felt in the real world on the ground. Another question we've got, I think this may go to sort of how the PSD program works. It says, please explain how the Duke Energy case, how Duke Energy could be regulated under PSD, and then is it due to the fact that the plants are located along state borders? Blaine, do you want to just sort of explain a little bit about how this works?
The PSD, for those of you out there who don't spend all of your time with the Clean Air Act, is the Prevention of Significant Deterioration Program. The Clean Air Act has two broad programs that are applicable to major stationary sources, and which program you have depends on whether or not you're attaining air standards or not. If you're not attaining air standards, it's the non-attainment new source review program. If you are attaining standards, you're subject to this Prevention of Significant Deterioration program, which seeks to limit emissions from sources, new sources, modified old sources, to limit those so that you can preserve your clean air in these clean air areas. The plants in the Duke case, and I believe in all of the companion cases, are in PSD areas, and so they are subject to the PSD program. New source review under PSD says when you build a new source, you have to apply best available control technology, and that is in some ways does not respect state boundaries. So you've got, in this case, Duke's got one plant in South Carolina, the rest are in North Carolina, but the pollution affects North Carolina, South Carolina, Virginia, the plants in Alabama, the pollution affects Georgia. So they have interstate impacts. Their status as a PSD plant that's not really bound by the state boundaries.
I think that pretty much that hits it, and that's sort of the basis of the NSR or New Source Review program, which is that it was a Clean Air Act program from the 70s, from 1977, that said that we're going to try to approach cleaning up air quality by looking at the area regionally and looking at regions. And so the states have to submit their programs, as Blaine explained it, but it's a federal program to clean up air quality region by region around the country. One other question we've got here is, if the opinion is such a huge victory for us, how is industry able to argue for delay? I think this might be referencing the Scott Siegel quote about how he was trying to say that the Supreme Court missed its opportunity to clarify new source review. I think the Supreme Court clearly did clarify new source review. This really does hit on the point that I was making a little bit earlier, that the industry tactic really is, if they don't like what they see, to pretend that they don't understand. As Bland explained earlier when talking about the Alabama Power case, there are a couple issues that still remain to be fought out. Specifically, in this case, essentially, industry has to comply if they increase their emissions. In this case, we win big because the emissions increase test we've been arguing for is the one the Supreme Court upheld. The next argument that the industry will say was, well, maybe we increased emissions, but we qualify for this routine maintenance exemption. So we'll go back and we'll fight on that and show how these massive overhauls with plants being offline for years cannot possibly be considered routine maintenance. And then the last argument that they'll have is to say, well, maybe this wasn't routine maintenance, maybe we were increasing emissions, but we didn't have fair notice that this is what the regulations meant. And so you can't enforce it against us unless you give us fair notice about what the regulations mean. Well, that issue will go back as well, but I think with the Supreme Court reading the regulations so clearly, it'll be hard for them to argue that they didn't have fair notice. The regulations are, as we initially explained, clear on their face.
Well, thank you, Cale. That's our last question. And thanks to everyone for joining us for this briefing. And please feel free to contact either Bland or Cale using the information you see on your screen, or consult our website at www.southernenvironment.org for up-to-date information on this case and our other work across the region. Good afternoon.